Hey guys, taking out civil proceedings under Part 3 of the Protection from Harassment Act in Singapore is an essential legal recourse for individuals facing harassment, stalking, or doxing. This law provides victims with civil remedies such as protection orders, expedited protection orders, and stop publication orders. Unlike criminal proceedings, which involve the police and prosecution, civil proceedings under POHA allow victims to take direct legal action to stop harassment and to prevent further harm. The first step in initiating civil proceedings is determining whether the situation qualifies under POHA. Part 3 of the Act covers various forms of harassment, including threatening, abusive, or insulting behavior, persistent stalking, and the act of publishing personal information with the intention to harass. If the conduct falls within these categories, the victim can apply for an order against the harasser. To commence proceedings, the necessary documents must be prepared. These include the originating summons, the supporting affidavit in Form 2, and a draft order. The originating summons is a formal document that begins the legal process, specifying whether the applicant is seeking a protection order, an expedited protection order, or a stop publication order. The supporting affidavit provides the factual basis for the application, detailing the incidents of harassment and attaching any supporting evidence such as screenshots, emails, videos, or witness statements. The draft order outlines the relief sought from the court, specifying what actions the harasser should be restrained from doing. Further information and documents can be found in the link below. Once the documents are prepared, they must be filed with the court through the community justice and tribunal system or the e-litigation system. Individuals must upload the completed originating summons, supporting affidavit, and draft order. Filing fees are applicable, generally ranging from $50 to $200, depending on the type of order sought. After submission, the court assigns a case number and schedules a hearing date. Following the filing, the next step is to serve the documents on the harasser, also known as the respondent. This can be done through personal service, where a process server physically delivers the documents to the respondent or harasser, or through substituted service, if the respondent cannot be located. Substituted service requires the court's approval and may involve methods such as email, registered mail, or even posting on social media platforms if necessary. The first court session for a protection from harassment court case depends on whether the case is under the simplified or the standard proceedings. A case management conference or case conference is usually scheduled 4 weeks after the application is filed. This is a court hearing in which a judge or an assistant registrar of the family court will manage the case, discuss the issues, and explore the possibility of reaching a settlement between the parties. If parties are not able to resolve the matter, the judge will utilize the case conference to manage the case, including giving directions relating to the preparation of the documents or other evidence by the parties until it is ready for hearing. If parties reach a settlement, the judge may record a consent order to reflect their agreement, and then the case ends. If parties do not reach a settlement during the case conference, the court may refer the case for mediation or counseling, if appropriate, to help parties explore a settlement without going for trial. If a settlement is still not reached after mediation or counseling, the parties will be given another case conference date. The case may then be scheduled for hearing, which both parties must attend. During the hearing, both you and the harasser or respondent will take turns to present your case and the supporting evidence. This includes explaining the harassment experience, submitting evidence, and demonstrating why the order should be granted. The harasser will have an opportunity to present his side, and the judge will then decide whether to issue the order. The judge will direct the flow and manner of the proceedings. The judge may ask you questions or direct you or the harasser to address relevant issues. The judge will make a decision based on the merits of the case and in accordance with the law. Possible orders that the judge may make include protection orders, mandatory treatment orders, and false statement orders. The Protection from Harassment Act is a crucial piece of legislation that offers victims an accessible and effective means of obtaining relief without the need for expensive lawyers. However, challenges remain, including the emotional and financial burden on victims who must navigate the legal system on their own. Although the process is designed to be straightforward and for victims to represent themselves instead of engaging lawyers, it can still be daunting for individuals unfamiliar with legal proceedings. Understanding how to take legal action under POHA is vital for anyone facing harassment. The law is in place to protect individuals from persistent and harmful behavior, but victims must take the first step by filing an application. Seeking legal advice can also help ensure that the application is well prepared, increasing the likelihood of a favorable outcome. That's all for today. Thanks for tuning in. Don't forget to like, share, and subscribe. I'll see you in the next video.